Have you given a young couple in your family a generous financial gift to help them on their way? Or have you been the lucky recipient of such a gift? Hi, I'm Simon Dippenaar and I'm a family attorney. Married couples are often grateful for financial donations from family members, often for a deposit on a property or other major purchase. But if the couple subsequently divorces, what happens to such a donation? In South African law, the question of whether a donation can be revoked during divorce proceedings raises complex issues. Unless a couple has an anti-nuptial contract, the default matrimonial regime is in community of property. This means that each spouse owns a half share in the joint estate. All assets and liabilities are shared equally, regardless of who acquired them. Donations made to either spouse, unless explicitly excluded or personal, are presumed to benefit both spouses. Therefore, when a donor transfers a sum of money to a couple for whatever reason, if the donation is not explicitly and officially declared to be personal or conditional, it forms part of the joint estate. Under South African law, there are very limited circumstances in which a donation can be revoked during divorce proceedings. The primary basis for revocation is ingratitude. However, this doctrine is exceptionally narrow and refers to serious misconduct against the donor, not between the spouses. The only sorts of acts that might be considered grounds for revocation for ingratitude include physical or verbal abuse of the donor, criminal behavior against the donor, serious defamation or fraud committed by the recipient against the donor. Simply being disappointed by or disapproving of the divorce is not sufficient. In the context of divorce, even if one spouse has acted dishonorably, for example, they have been unfaithful, the courts are unlikely to permit revocation, unless the conduct is targeted at the donor. Donors who feel aggrieved during divorce proceedings often threaten legal action or intervention. However, to be allowed to intervene in a divorce, a donor must demonstrate a direct and substantial interest in the matrimonial estate, prove the existence of a conditional donation or contractual breach, show that their financial rights are materially and legally affected by the divorce. Without a clearly defined legal interest, the court will not permit interference in divorce proceedings. Even in the rare event that the court acknowledges the donor's legal standing, the donor must show that a written donation agreement is in place, the terms of the donation have been breached, legal restitution is appropriate and not simply morally desirable. The courts closely examine the donor's intention at the time of making the donation. For instance, if a donation was described at time of giving as a gift to help the couple settle down, this is treated as an unconditional gift, unless there is formal language to the contrary. Attempts to redefine a donation in retrospect as a loan, trust contribution, or conditional gift will almost always fail if there is no documentation dating from the time of the gift. Once an asset is donated to a joint estate without explicit conditions, it becomes jointly owned. Divorce does not alter that ownership. Donors who have made financial gifts to couples married in community or property may feel disappointed when the couple divorces. The same is often true of friends who have given generous wedding presents only for the couple to divorce after a short time. However, the law offers limited remedies to revoke or reclaim such donations, especially during divorce proceedings. Basically, once a donation or gift becomes part of the joint estate, both spouses have equal rights to it. Revocation is only possible under narrow, exceptional conditions. To avoid future disputes, if you are giving a gift to a family member who is married and you want to be sure it remains their sole property, document your intentions clearly and consider legal instruments such as loan agreements, trust structures, or conditional donations with written stipulations. If you're considering making a substantial financial gift to a couple and would like to discuss the best way to do that, get in touch with me on the number below for a confidential discussion.